So there is an element of legal part, there's an element of contractual part, there's an element of administration part. All those, this is an integrated competency which include different subjects or different competencies merged into one. So even this MRICS competency, I would take it as a more like a practical competency that going to help you in your day-to-day career. Okay, so this is something level 1, level 2, level 3 things which I'm not going to touch base right now. This is something which we follow when you're writing an SOE. I'm sure most of you all must have already attended our sessions on icebreaker and all, which we explain like level 1, level 2, level 3 and all. So this is the heads up how you going to write the level 1, level 2, level 3. Why I'm not explaining right now, because first you have to know what is inside this competency. When you know what is inside competency, you know what exactly it mean by the examples. Now when I say basic contract law, you don't know what is basic contract law. So let us learn first and come back to level 1, level 2, level 3. Okay, so this is what we're going to touch base today, not today. This is what we're going to cover under this competency. We have planned like levels 11 session for this competency. That means connect practice and administration together. We're going to have like 11 sessions, say 22 hours of section. Okay, in that we will be covering principles of contract law, legislative requirement, then standard forms of contract like FIDIC, JCT, NEC, ICC, etc. Then we will be explaining the roles and responsibility for parties, like in the contract, like we have client, contractor, subcontractor, everybody is there. So we'll be explaining what RIC is expecting from these roles. Then we're going to explain assignment, novation, third party rights, LOI, LOA, performance security, and deep into that, guarantees, the function of guarantees, insurances, advance payments, interim valuation, MOS, that means material on site, off site, fluctuations, retention, change procedures, value engineering, extension of time, claims, dispute avoidance mechanism, names and nominated subcontractors, sectional completion, design portions, performance specified work, determination, final accounts, completion, liquidation and delay damages, defect liability, and of course some intent of technology concern also. So this is like when I'm reading these points, you know that it's covering many items, because you can see advance payment here. Same times you can see principles of contract also. Advance payment, it's in post contract, but principles of contract law is it's legal item. So it's a merger of many major competencies from contractual and legal perspective. Okay, so contract practice definition. Okay, the contract practice means whatever happened before you sign the contract. I'm asking the first question I asked you like about yourself, whether you work in a pre or a post contract. I just want to know where you work exactly. So that means, are you working in a stage before sign the contract, or are you working in a stage after sign the contract? So the contract practice this means by definition it states refer to the process and activities involved in the creation, negotiation, and formulation of the contract before its execution. So just keep it in mind. Whatever I'm going to explain, whatever I'm going to narrate you, are going to happen before you sign the contract. It's all about how you mold the contract or how you present the contract. Nothing in terms of administration. There's no administration at all in these competencies. In these competencies, we're discussing things whatever should have happened before you sign the contract. Now you might be wondering, in the previous slide, you shows us advance payment. Advance payment is something that should happen after the sign off. Why are you telling or explaining that competency over here? So why I'm explaining that competency in this session, or why RICS included that session here? Because you should know what is advance payment. You should know the function of advance payment. In the post contract, as a quantity surveyor, I mean a contractor's quantity surveyor, you might have already applied for advance payment. And as a consultant QS, you might have already certified for the advance payment. Okay, so what we do touch base in this competencies, why advance payment and what is the function of advance payment and why we have to agree the forms and other innards before you sign the contract. Okay, so this competency is all about what would happen before you sign the contract. Before we enter, let me introduce some terms of the contract. It's more like legal terms, but since we're going to work in a contract, we should know the legal part of also. Okay, if you look in the definition of a contract, it's a binding agreement between two or more persons which create mutual rights and duties and which are enforced by law. So you have to by heart this definition because in RIS's interview, if they ask you about definition, you have to reproduce same answers to them. So it's a legally binding agreement between two or more parties which have a legal enforceability. Okay, but before you by heart, let me explain this term. There is something called a promise, then something called agreement, then something called contract. Okay, so that means an offer is there, an acceptance is there, and again there is something called promise, contract. Hi Nisar, you there with me? Hi Nisar, can you hear me?
Yes, I can hear you.
Nisar, tomorrow I'm going to give you a CPD. Could you attend, please?
Yeah, sure.
Sure. Huh?
Yes.
Okay. Tomorrow I'm going to attend a CPD that's going to cost you 10 dirham. Are you okay?
Yes, it's fine.
If you're not attending, I'm going to sue you. I want to make it formally. You want me to? I want you to sign an agreement to attend the CPD. Can you do that?
Hmm. What is my benefit?
If
I
you're not
could make.
if you're not attending, it's going to be a legal case against you.
Hmm. I have to think about it then.
You can say yes or no. No worries.
Yeah, yes,
You can attend, right?
yes.
Okay. Thank you. Hi, Safar. Safar, you with us? Hi, Safar. Can you hear us? Okay. Tamis.
Hello? Yeah. Am I audible?
Who is this? Safar or Tamis?
Suffer. Yeah.
Okay, Safar. Safar. Uh, I have a movie ticket with me. Can
Okay.
you come with me to watch? Safar? Maybe he's not interested to watch.
Hello?
Yeah, Safar. I have a movie ticket with me. Can you come with me to watch the movie?
Yeah, sure, sure. Of
Sure.
course.
Thank you
I
very
will come.
much.
Yeah.
But you need to pay me off ticket price.
That's fine. Okay.
Fine.
Fine.
If you're not coming, there could be a legal issues also.
Okay.
Okay?
For the
You're
movie
okay with
rights, it's fine.
I will let you know your rights, your obligation. I will let you know my rights, my obligation also. Okay?
Okay.
We have to
Sure.
sign the contract. Okay?
Okay, fine.
So now let us decode. In first example, I ask Nizar, I can give you a CPD. Could you attend? He said yes. That means a promise is created over there. My offer was, can you attend the CPD? He said yes. He accepted my offer. My offer was, can you attend my CPD? He said yes. So that what created is a promise. It's not an agreement. It's not a contract. It's a promise. Then second case, I told him like, but you have to pay me 10 dirhams. Still he said okay. So what I added is 10 dirham. That 10 dirham is called consideration in terms of legal context. Okay. 10 dirham is called forgot about the 10 dirham. That money or something is called consideration. So there was a promise. I told him I going to give you a CPD. He said yes. He going to attend. A promise is created. Then I said, cleverly I said, Nisar, you need to pay me 10 dirham also. Still he said yes. So a promise plus consideration form agreement. I was very clever actually. I was like, in this case, I acted even clever way. I said like, Nisar, I can give you a CPD, but still I want to make it formal because you may run away without giving 10 dirham. I don't trust you, buddy. So, why can't we sign a contract? It's not big deal. Let's sign a contract in case if you're not showing up. I know you will come, but in case if you're not showing up, can I sue you or can I file a case against you? He trusts me. He was very happy with me. He know it's a very genuine request only. He said yes. So a promise plus consideration. That promise against a money or a service is agreement. But agreement is not a contract. Only when adding the element of legality, that agreement will become a contract. Okay. Promise. If like sometimes you like, come, let's go for a movie. That's a promise only. But if he's not coming for a movie, I cannot sue him. I cannot file a case against him. Again, I'm telling, come, let's go for a movie. You take the 10 dirham, or you draw me, or you give me, you owe me, what do you call that? You buy popcorn and drinks. So promise is like, so my offer is, come, let's go for a movie. Then Safar said, yes, he can come with me. Then I'm telling, but you have to buy popcorn and coke. He said yes. In this case, the consideration is not money. In this case, consideration was a service. So just keep it in mind, guys. The consideration may not be always money. It could be a service or anything of value. Okay. If I connect you in a contractual way, I'm telling a consultant, please prepare a BOQ for me. But I'm not going to pay you. I will give you one more contract, or I will appoint you as a consultant in a upcoming project. So in this case, consideration is a offer to award him a next contract. There's no monetary value. This also a consideration. Okay. Or else I'm telling a contractor, dear contractor, please construct a boundary wall for me. I will give you some a trip to USA. I will give you a ticket to trip to USA. That also a consideration. But when you adding the legality, there is an agreement, but you telling, I want to make this agreement in legal. I don't want to randomly agree something and move forward. I want to make it legally bindable. I want you to sign the contract. I want you to attest it by the government. If that is okay, that means when you are both party ready to make it enforceable by the law, then become the contract. Okay. Hope is clear. If you have any doubt on contract, because you should understand this concept clear, then only you will understand the upcoming concept. Are you clear with the concept, guys? I'm talking about the concept of contract, how a contract is formed. Clear with that? Any doubt? Yep.
Midun, about this legality part,
Yeah.
actually.
Yeah.
How means if you are giving an service on behalf, okay. How can be this legal part can be taken into consideration? I'm like,
that's why
I'm going.
Nisa, right?
Yeah.
Okay. Yeah, go ahead.
No, for example, you asked me a service, okay, or you offered me a service, okay, and you told me there is money for that service.
Yep.
Okay. But you already told me that if you are not coming, means there will be a legal issue against it.
Yeah. Not like that actually.
But I'm saying you offered me a service, but I'll have to pay for it. But how come it can be a legally binding?
Okay, I will tell you. I want to make it legal. I want to make it legally binding. Okay. Agreement is, you said yes, I said yes, there is a money. Agreement is formed. So I'm telling, okay, I'm telling Nizar, Yes, we have an agreement, but I need to make it a contract because I need to add the element of enforceability. I want to sign it. I want to stamp it. Some country they need to
Yeah,
make
yes,
in a
yes.
stamp paper. Some countries
Yeah.
they make in attest by the government. That's the enforceable way. How you make
No, because
an agreement into a contract.
what I was trying to say is some people might I have seen some companies signing like blank papers like, but it's not legally binding, right? Can we call this a
Depends
contract?
on the country. Depends if your
Yeah,
country demand that documents to be stamped in a or signed in a stamp paper. That, for example, India. In India, you need to buy the stamp paper to make any
yeah,
contract.
yeah.
Okay, that's the money for the government also. But in your country where you're working, it's not required. Means you can just sign a contract or a paper. What you say, like you draft a contract, both parties sign, both parties stamp. That's a legally binding document.
Yes.
If you remember, if you I don't know whether you come across some companies has to convert into a Arabic. I mean, mainly we all in GCC, so it has to translate into GCC by the government, and then only it will be valid. Only those documents will be approved by the government before giving any permits. Okay,
Okay, got it. Got
clear,
it.
right?
Clear.
Any doubts, others, guys? Before I move to, can I ask you a question to a young 5 years old guy? I mean, 5 years experienced person. Sarika, you understood this concept?
Yes, I understood.
Understood, right? And I'm sure, like, others like you have pretty experience. You might already come across these items. But again, just for Binsha, you got it clear with you, Binsha? Any doubt?
No, it's clear, Midun.
Clear, right? Okay, thank you. Safar, I'm not going to give you a movie ticket, but still you understood?
Yeah, clear.
Clear, right? The concept I'm talking about.
Yes, yes.
Thank you. So now let us look into elements of contract. If you are a contracts manager, if you're a commercial manager, say if you're a quantity surveyor, okay, before you sign the contract or before you draft the contract or your manager give you the contract and telling you to review the contract, what you do basically when you somebody, if your manager told you to review the contract, what is the first step you do? Just tell me like what the first step you do when you receive the contract. Rafi, can you tell me like what you do in the first step when you receive the contract? Or how do you review the contract, Rafi?
Contract document. I will
Yeah,
go through the
how do you
contract
review
document.
it?
Is a remeasurable or lump sum
Mm.
type of.
Okay, go ahead, I'm listening.
Yeah. And the scope, I will study the scope
Okay.
and the specification,
Mm.
drawings,
Okay.
and those things.
Okay, thank you. Ahmed Moza, what do you think? Like how do you review the contract? Just for, just to know how you do a contract review.
Can you repeat your question again, please?
I just want you to, if you could explain us like how you review a contract when you receive a contract. Yeah,
First thing, I will check every party obligation, responsibilities, rights. Uh, I will check. I will, but it depends from which point of view I review the contract, even employer side or contractor side. If
say employer side. Employer side.
employer side, I will check
Yeah,
my responsibilities. What shall I give to the contractor? What my responsibilities, my obligations? What is the risks?
they're in the contract.
Who will bear the design responsibility? Who will provide electricity and water? Who like that?
Got it. Got it. Thank you. I'll ask you one more. Ask to one more guy. Binsha, can you tell me like how you review a contract?
Hi, Midun.
Yep,
Like,
Binsha.
it depends, like, whether I'm like a consult, like from the consultant point of view or the contractor point of view.
Okay, say contractor point of view. No, employer point of view or a consultant point of view.
Like from the employer point of view, will be mostly focused on the rights of the employer, and
Mhm.
also like
I see rights of
regarding
employers
the,
and yeah.
yeah, regarding the timelines,
Okay,
schedules, milestones, payments.
okay. Thank you, Binsha.
Yeah.
I need also to add something, please. We shall also check about the applicable law if we have
Hmm.
arbitration agreement or not. Uh, Such this point are very important also.
Okay, thank you. So guys, I'm really happy the way you explained because your terms, those are, of course, very important. But before you receive a contract, just imagine your employer, your manager give you a contract, and he's telling Pinsha review it or Musa review it. Don't you before you open the contract or before you sneak into the specification, you sneak into the terms, sneak into the obligation, sneak into the responsibility. You have to ensure these points which you could see offer, acceptance, lawful consideration. These things what you can see is there because in my previous slide I explained offer plus acceptance is promise. Promise plus consideration is agreement. Agreement plus legality is contract. If those items are missing, if one of the item is missing, there is no point you open the contract and you review the terms, you review the capacity, you review the obligations. So these points 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 points. This is the first thing you are to ensure so to qualify it as a contract. There is a terms and condition, there is FIDIC, there is critical condition, there is specification, there is drawing, there is BOQ, many things. But before any of those items, you have to make sure the document you received is a qualified contract. To make any document a qualified contract, you need to have these 9 elements. So let us look in this element so that next time when you receive a contract, you make sure these elements are part of the contract. So I would appreciate if you could open an Excel and top elements of contract, list these 9 items, and before you got the contract, you put a tick mark 1 1 1 2. Yes, offer is there, acceptance is there, consideration is there, free consent is there. This 9 item you put tick mark, then you can say it's a valid contract, and now I'm going to review the terms and condition, specification, obligation, responsibility, everything. So let me explain what these items are. Offer. So offer I already explained you is a person giving a proposal to other party. Yes, Navid?
All these are the elements of the contract, isn't it? This will be available in the first page of the contract in whereas column that
No.
the employer got the offer from the contractor.
No. I will explain, Navid. I'll come back to your question, okay? Let me explain and
Okay.
come back to your question, okay?
Okay.
So let us see. Offer. So an offer is when one person presents a proposal to another. Hope all of you know about that. Offer is something when one person present an offer to a proposal to other, just like a contractor and an employer, okay? For time being, you forgot about the tendering process, okay? I'm talking the contract in a legal perspective, okay? Not in a contractual perspective. First, the legal part of it, okay? So it's more about a person giving a proposal to other. Let us take this way. I'm an employer. I'm calling a contractor and telling, dear contractor, please construct this building for me. I'm going to pay you 100 million dirhams or real. That is the offer actually. Here, what is my offer is construct this building for you. That is my offer. Now I will explain when it comes to construction contract how it's going to draft. I will explain, but this is the concept of the offer. The person who gives offer is called offerer or promiser. Okay, so an employer, say me, I'm an employer, I'm calling a contractor and telling him, dear contractor, please construct this home for me. For I'm gonna pay you 100 million. That is the offer. Okay, that's the offer. Just let me remind you the example when asking Nizar and Suffer. I give an offer to come watch movie and give offer to attend my CPD. Similar way, same fashion only. Okay, but let us look into some legal perspective of like offer. The first point is that there should be two or more parties. The person who give offer is called offerer. It has to give a second party. Okay, again, offer should be communicated to the offeree. If you are an employer, why I am telling this point, if you are an employer, your offer you are to communicate to the contractor through a proper channel. Could be a tax, could be a mail, could be any other mechanism. You have to communicate to the persons. A employer and other company, you have to communicate to the offer to the person in the a right person who can take decision, or you who have power of attorney. The offer should be addressed to him. Okay, again, if you just a mere telling is not an offer. You randomly telling, oh, I maybe give you 10 million for constructing my home. That's not an offer. It should be a very specific offer. It should be very specific in terms of nature. Okay, any statement you made a joke, I'm going to sell my car for 1 dirham. That's a joke. Nobody will sell a car for 1 dirham. That's not an offer. Just imagine if me and Nisar sitting and I'm telling casually, Nisar, I'm going to sell my car for 1 dirham. He jumped and said, yeah, I will take it. I'm accepting an offer. Now you give me offer and accepting. If you're not giving, I'm going to sue you. That's not an offer. Something made of a joke is not an offer. So the point, offer should be specific and it should be communicated. Okay, and it should be certain, it should be communicated. An ambiguous offer is not an offer. It should be, so if you're an employer, guys, be very careful. If you're an employer and if you're giving an offer to contractor, it should be very specific. When you draft a contract, it should be concession, supply, installation, testing, commissioning of the villa or a building known as this name under the affection plan attached in the appendix A. Something now it's very specific. Just if you write only offer as concession of the building, that's not specific actually. You are specifying the building, building number, permit number, affection plan, that become a specific offer. So it shouldn't be ambiguous. If your offer is ambiguous, you are not getting the benefit. Other party getting the benefit. Okay, so it should be communicated. So whenever you draft a contract or you send an offer, make sure you communicate properly. Second case is, please make sure you had made an offer very specific. Okay, when I explain offer, I want to tell you about counter offer also. A counter offer is something. So I will take the same example where I'm calling a contractor and telling to construct a building for me for 100 million. The contractor is telling, no, I cannot construct for 100 million. I need 120 million. This is called counter offer. I give an offer of 100 million. He said, no, I cannot construct for 100 million. I need 120 million. That is called a counter offer. So when you receive a counter offer, your original offer will cancel automatically. Again, it's a legal doctrine only, but you all need to understand what is meant by counter offer. Okay. So offer again classified into mainly the main classification is express offer, implied offer, specific offer, general offer, counter offer, and standing offer. It's not very important, but just good to know. Express offer means you are expressly giving an offer. That means you're calling the contractor and telling, dear contractor, come and do this work for me. That's an express offer. But implied offer Just imagine you are constructing a building. In front of you, there is a shop. A shop who sell cement. He used to sell cement, rebars, everything. So whenever you want cement, you just wave at him, or you just wave at him, or you just, you know, give a whistle to him. Soon he hear a whistle, he will give you the uh, cement. That's called implied offer. So waving, that means your the circumstances or your gestures that show your offer. There's something called specific offer, which is very important because in construction industry we have to give specific offer. We are giving offer to exact the company. That is the reason when you prepare the contract, you are to put the full address of them, including the PO box. General offer means offer which you sometimes open tenders. Open tenders sometimes back in 80s and 90s, what they will do, uh, employer will publish like this: we going to construct a villa, and the offer is you have to construct it for 10 million. If you interested, please come. They will publish in the paper or any publication. Anybody can participate, anybody can accept it. Then they will decide whom to give. That's called general offer. The counter offer I already explained, like offer against an offer. There is something called standing offer or continuous offer. An example is tender, because you giving an offer and opening the offer for a period of time. You said this is the specification blah blah drawings, and I want you to say yes or no, or give you an offer or acceptance within 3 months or 2 months, whatever. That's called standing offer or a continuous offer. Okay, so guys, when you reviewing a contract, please make sure there is a very specific offer, be it from contractor or be it from the employer, because if employer giving the offer, contract has to accept it. If contractor is giving a counter offer, employer has to accept it. It should be communicated properly, it should be addressed properly, it should be expressed correctly, it should be specific also. So this 4 point has to be in your mind before the first step your review of a contract is make sure you have a proper offer. Open the contract and see, yes, there is an offer. The contractor agreed to construct the building, whatever, with the name of this for this. That's the offer for this amount of money, whatever, which is expressed. So it's expressed offer. It's specific. You correctly mentioned what exactly going to construct and is communicated. So that means the legal elements of offer is fulfilled. Because if it's not fulfilled, in the worst case scenario, if you go to the court will find in their benefit, because you are the one who draft the contract as an employer. As an employer, you are the one who draft the contract. When you go to the court will say you are the one who draft the contract. It's not specific, it's very ambiguous how the poor contractor will do the work, so you will not get the benefit out of it. So that's about offer. Now let us look into acceptance. So acceptance means when one party given the offer, other party has to accept it. Okay, but acceptance should be unconditional acceptance. If you accept in the contract, if you accept in the offer, it should be unconditional. You cannot tell him, yeah, I am not accepting the offer, but subject to blah blah things. That's not entertained, or that's not a valid acceptance. If you send an offer to a contractor, just imagine you send a contract, you prepare a contract, okay, and when he signed the contract, or when he accepting the LOA, if he puts some qualifications, okay, that means uh, just imagine a scenario where when he signed the contract, in the bracket or somewhere he write down like accepting the contract subject to employer will provide me this thing, that thing, or employer will provide me scaffolding, employer will provide me water supply, employer will provide me subcontractor, something he writing down. That is not a valid acceptance. If there is no valid acceptance, please keep in mind your contract is not valid at all. So acceptance should be unconditional. One of the key aspect. So when you receive a tender return, then the contractor submit a tender for 10 million. You have to make sure that is unconditional. There is no qualification, no exclusion. Because if such things are there, that is impacting the validity of the contract. So in a legal term, they call it as a absolute and unqualified offers. So a contractor or a supplier or a subcontractor should accept, say if he's delivering something, he should accept, yes, I am going to deliver the material to you. But what if here accept like that, I am accepting to delivery material subject to if you provide me 1 billion, or if you provide me a security, or if you provide me transportation, that's not a valid offer. And if the offer is not is unconditional, sorry, if acceptance is conditional, that is not a valid acceptance. Again, next steps, acceptance should be communicated. That means when you send an offer, okay, say if you send a contract or RFP, whatever, or if you send a LOA, okay, if you receive an LOA, you sign it and you keeping with you. You didn't communicate to him. That is not an acceptance. So when you sign, if you're ready, you have to communicate back to them. Yes, I'm ready to do the work. I'm unconditionally accepting. So it has to be communicated. So guys, make sure when you review the contract, there is a acceptance communication from the contractor. How do you ensure this thing? I'm just asking out of curiosity. How do you ensure this acceptance confirmation or like communication? If somebody work in pre-contract, you can try this asking questions. How do you ensure this acceptance is being communicated? What is the mechanism you'll use?
Letter of acceptance.
Who's this?
Letter of acceptance.
That is after signing the contract. What we're talking about is purely before the contract. Because
before the contract.
Yeah.
LOI.
What is that?
LOI.
Like
Not really.
letter of acceptance, LOA.
Not really. Somebody else want to try?
Can you repeat your question again, please?
So what I'm asking, like, you know, how do you ensure this?
There won't be any exclusions.
There won't be any exclusion. Okay, correct. Now my question is
No.
Mosa actually. Communicate as I mentioned, the acceptance should be unqualified and should be communicated. Okay.
It should be accepted. Okay.
How do you ensure that in a pre-contract stage? Yeah, when you send a LOA, it's a post-contract. You know that it's communicated. So how do you ensure in a pre-contract?
No, I'm not sure. Sorry.
No worries. Somebody
Valid
else.
offer.
So who is this?
Valid offer.
Valid offer. No. Anybody in pre-contract? What is LOT? What is LOT?
Letter of tender.
Letter of tender. So when you submit back the RFP, there's a LOT, right?
It is the full compliance of all the ITT documents and compliance.
Yeah, compliance with, and you put the amount also, a letter of tender. Letter of tender is a part of the contract also.
Form of tender, right? Form of tender also.
Letter of tender. Let's call letter of tender.
Okay.
Okay, and when you prepare the contract, that's a document. LOT is a document also. Letter of tender, isn't it? In FIDIC form of contract.
But letter of tender usually comes as a priority after letter of acceptance, right?
Yeah, because when it comes to acceptance, there is already there is a acceptance, offer, and consideration. So don't need to worry about the communication. There is already a signature between the parties. But this is before that. Okay. what I'm trying to explain, the essence of communication, why communication is important, and why we are or why we are how we are ensuring the communication. Okay. So as I said, it should be unconditional acceptance. It should be communicated properly, and it should be communicated to person who give you the offer. That's the main important thing. Okay. When you prepare a letter of tender or a letter of whatever, it should be addressed to person who supposed to accept the offer. He should be the person who should be able to sign the contract. And any acceptance subject to the condition is not a valid acceptance. Okay. Hope it's clear with all of you about acceptance and the offer. Why I am emphasizing this point, it's very important because any of these are missing, your contract become void. Okay. So be very careful when you're reviewing the contract. From next time onwards, make sure offer acceptance is valid. Okay. Now let us go to the consideration part of it. A lawful consideration. That means you should be able to, or you enter into contract do for something of benefit. It need not to be money. It could be anything of value. Okay. I hope this example, like I'm telling a contractor to do a boundary wall for me, but I told him I'm not going to pay you, but I will give you a ticket to USA. I will give you a leisure trip to USA, something like that. That is called an offer. But the main thing you have to keep in your mind is the offer should be lawful. What do you mean by lawful offer? What is the difference like lawful offer? Lawful offer is that I'm telling a contractor, let us enter into contract, but I cannot pay you money. I will give you black money. That means I don't want to register this money in. I give you 100 million, but I will give 20 million in cash, or we will show only 20 million in the paper. Or other way, I'm going to give you consideration. I can give you some bottle of beer. Come and do the work for me. I'll give you some drugs. Okay, come and do the work for me. I'm going to give you some brothel service. Come and do the work for me. I'll give you some weapons. These are not lawful consideration. So consideration should be lawful. That's very, very important. And one more thing, it cannot be zero also. Okay, just a case. Musa and me are very close friends. Okay, so we are very good close friends. I'm telling Musa, just I want you to do some work for me. Then he would say, no problem, Mithun, I can do you free of cost. If he do the work free of cost, and if we prepare an agreement, that is not a valid contract. Consideration shouldn't be zero at any cost. It can be 1 dirham or 1 rial, but it can never be zero. Because if you doing any work without accepting a money, that's a charity that will not qualify as a contract. But there will be sometimes, you need to do the work for him, but through a proper channel. You need to define obligation, responsibility, everything properly. You have to mention dispute mechanism. You have to mention all the requisite terms. But again, you don't need to pay me. I can do it for free. In that case also, you need to put minimum 1 dirham or 1 rial. Sometimes I'm sure you might have come across such scenario also. Some contractor will say, I can absorb this money for you, so please don't pay me. Some variations. Please put 0.1 dirham at least as a consideration. In the worst scenario, if it goes to court, they will say there is a consideration of 1 dirham or 1 rial. It's not a invalid or a void contract. Offer acceptance consideration. If any of the factors is mixing, that's not a valid contract. So when you prepare a contract like this, please make sure you at least consider a minimum value for that. Okay. That's the main legal rule for consideration. It should be lawful. It cannot be zero. At least a minimum. And one more thing is that it may not be accurate, or like, sometimes you say you're constructing a building, it minimum going to cost you 100 million, but you give a contract for 50 million because contractors say no problem, you are a very good employer, you have been giving me many contract, so this work I'm going to give you a discount of 50 percentage. Somebody looking from outside, they may think why this is, say I'm telling a leak, it go to a court, they won't look into that perspective. They won't look in that perspective like this is not sufficient, why this contractor is accepted the offer, why this is for agreed for very less amount. They will not look into that perspective. Okay, it not no need to be sufficient, but at least something. It cannot be zero, it should be lawful, and it need not be sufficient also. These are the main thing you should consider when reviewing the consideration part of a contract. Okay, that this is the money thing, something in return, that's only the consideration. So you open the contract, they mentioned 1 dirham is okay, if you mention 0 dirham, you should tell there is no proper consideration for that. Or if you see the in consideration they write I will give you 100 bullets or 100 weapons, that's also not a legal consideration. Okay, let us move to other part, free consent. Free
Sir,
con
brother,
Yep,
sorry for interruption.
yep, go ahead
Sorry
please.
to interrupt you. Can you explain that one you told about 50 percentage from contractor
uh,
side?
I mean to say acceptance no need to be sufficient. That means say a villa project. Okay, so a villa project, it going to cost 100 million. Okay, so that is the actual value. As an employer you should pay him. Okay, you with me? Hello?
Yes, I'm listening.
You use actual value, or if you want to construct that villa it should be 100 million, say dollar, dirham, whatever. But the contractor is telling, dear employer, I can give you 50% discount, I'm going to consider for 50 million only. After price he agreed. Okay, he start the work. When initially everybody was very happy, client is happy, contractor is happy, he start the work. But moving forward, slowly issue come, and there is a big issue, fight happened between employer and contractor, and it went to the court. Okay, it went to the court, and the court, what a normal person will think, what you will think when, and you are a common man, you are telling this contract is 100 million, the contractor is explaining you. Okay, you ask him like randomly, you ask what happened, what is the issue. He's telling, see man, this is a 100 million contract, still I agree to do for 50 million, but still he's making issue. What you will think now?
However, there is a contract. He agreed to
Yeah, yeah,
do
yeah, but
it's
just
legal.
focus on the 50 million. What do you think? Forget about the
From
contractual part of it. What do you think?
humanity side, it's
Yeah, humanity side only. Yeah.
this is okay. Like client has to do some adjustment. Okay, need to approach in
Yeah.
different way.
Now client is
It's
telling you, dear, by the way, who is this? Who is asking question? Safar, right? Or Rafi?
Rafi.
Rafi. Okay, so client is coming to Rafi. This guy only give me discount. You are telling client, dear client, what is this? You should have paid 100 million. Now you make it 50 million. Then client is telling, no, Rafi, this guy only said he going to give me 50 discount. He only told me like that. Now what do you think?
Need to do some consideration.
Consideration. Okay. Now it's go to the court. Okay.
Okay.
You was the mediator. They both came to you, but you are not able to make any decision. It go to the court. Okay, but court will never look into the figure of consideration. Even it's 1 dirham also, he said okay, there is a consideration. He will not look whether that amount is sufficient or reasonable. That's what I meant. Even it's a 1 dirham also, court will check. Yes, consideration is not 0, it's 1 dirham. I'm okay. The contract is valid. That's it. He will not tell, oh, you're considering this big building. Why are you paying only 1 dirham? He will not ask. He will never ask that. He will look the validity of contract and he would say there is an offer, there is an acceptance, there is a lawful consideration also. That's it. That will be the full stop. Clear now?
Yeah, it's clear.
Clear now. Thank you. So now something called free consent. Now next you have to ensure the both parties sign the contract with the free mind. Both party happy to sign the contract. Nobody push them, nobody threaten them, nobody induce them, nobody deceive them. That is the main thing, free consent. That is very important thing actually. The both party, because if me and somebody is entering to a call, just Rafi and me, I don't know Rafi, the first time I'm interacting with Rafi, okay, so me and he should enter into a contract with free mind, completely free consent. Yes Rafi, I'm happy to enter into a contract with you. Same time he should tell me, yes Mithun, I'm also completely with the free mind, I'm coming to your contract. But instead of that, my friend Nisar is going. Nisar going and telling Rafi just sign contract because Rafi don't want to sign the contract because I put some crazy clauses. I put some unreasonable clauses. I told him like even 1 day delay in LD will be 100 million. Completely unreasonable, right? But you know, so he said he don't want, he's confused, he really don't want to sign the contract. So Nisar is my friend, he went to Rafi and said, Rafi, just sign the contract, Mithun is a nice guy, he will not sue you, he will not cheat you, you just sign the contract bro, no problem. So the Rafi may sign the contract, but he don't have that free consent. Other way around, okay. So Rafi suppose sign the contract and Rafi is not happy with the terms of condition. So he is about to step out. He said, I don't want to be in the contract. Suddenly, I'm calling, say, Safar is my friend or Shafat is my friend. And Shafat, so I'm telling Shafat, you go, you threaten him, you just hit him, you just somehow, or kidnap his kids, kidnap his family, somehow he had to sign the contract. So he and the team went, he kidnapped his family and tell him, Rafi, if you not sign the contract, your family is with me. I don't know what I'm going to do. This is then he may sign the contract, but not with a free mind. Okay. So we got to ensure he should sign the contract without any of this. There are main things you have to check. There is no cohesion. There is no duress. There is no undue influences. There is no misrepresentation. There is no mistake, and there is no fraud. Cohesion means the first example where they would say they would call and say I'm going to kidnap your family or I'm going to hit you. Maybe he'll go hit and in cohesion, maybe physical damage, physically they will assault, or non-physical threatening. All these things are cohesion. Sometimes it happen also. Sometimes this property dealers, they maybe find some property, maybe the owner will not is not willing to sell the property, then these goons will start calling the owner, you sell or not, if you're not selling, I'm going to hit you, I'm going to kill, maybe he will hit also, maybe he will physical damage his property, he will kidnap his family, many things. This is called coercion. If there's no free consent, okay, the contract is invalid, but the problem is very, very difficult to prove this. Very difficult to prove. But if you something have a phone record or you have a message backup, easy, still easy. But normally it's very difficult to prove and you have to prove. If Rafi told me or he went to the court and told I signed the contract without consent, there was a cohesion, Midun and team hit me hard or he threatened me, then you have to prove. The party who claimed that, he has to prove that there is a cohesion. In cohesion, there is the threatening will be there and a physical damage. But in duress there is a physical hit only. There is no threatening only. Straight away going and hitting and tell I'm going to hit and kill you if you don't sign the contract. Okay, there's something called undue influences. And just imagine uh, Nisar and Rafi, they're colleagues. Rafi is a quantity surveyor and Nisar is his manager. Okay, so Rafi expect to have a contract with me, same contract, but I write unreasonable thing on that. So Rafi said, no, I don't want to enter into contract. So I called Nisar. Nisar, you are his manager. Tell him to sign the contract. You influence him. Then Nisar will go to Rafi and say, Rafi, he's a nice guy. And if you're not signing, maybe I will stop your increment. Maybe I will. He will not say directly, but he's using his power. He will try to influence Rafi and make him sign the contract. That's called undue influences. You will indirectly tell him, okay, you might not be getting increment this time. You might not be getting bonus this time. Or, it's just a basic example. Similarly, using the power, sometimes, politicians, police people, bureaucrats, they will do this undue influences. Something called misrepresentation is basically the facts are concealed actually. If I want to sell a property, I will show him some other property and sell. There is a property, then he would say, I want to see the property. He would say, I want to see the building. I'm selling my building. Then I will take him to the place and show some other building. Whereas I supposed to sell some other, my building was damaged completely, but I show him some other person's building and cheat him. That is misrepresentation. There's something called mistake. Mistake is like, it's sometimes happen intentionally and sometimes happen unintentionally. Okay, so intentional mistake is that the same example, misrepresentation. uh, I'm showing him something. I show some other's property and told Rafi, this is the property, you take it. And I know well that this is not the property I want to sell. Then showing something else, I convince him and I take money from, and then I disappear. Okay, just keep in this way. I'm a broker. Okay, I'm a broker, or then there is two, three persons in the mid. So instead of showing the proper thing, or maybe the persons told me that this is the property. I also don't know this is the property or not. That's unintentional mistake. In the first case, I know this is not the property, but still I cheat him. In the second case, I don't know this is a property or not. That's unintentional mistake. Then something called fraud. Fraud means, materialistically cheating or deceiving the persons, showing fraudulent documents, forged documents. All these are coming under the fraud activity. But again, these are mainly coming in the sales agreement, property agreement. But for us, maybe you have to look into undue influences, coercion, and duress. That's it. Okay. Now let us look into capacity of party. That means, does the party has capacity to enter into a contract? If a party who don't have capacity, if he sign the contract become void or voidable. Okay, so what is your understanding about capacity of party, guys? Can I just ask you? It's a new session. I'm just getting familiar with the names and all. So Adi, can I ask you what is your understanding about capacity?
The person who is in charge to accept the offer.
Should be in charge to accept the offer. Okay, how do you ensure that?
Power of attorney.
Power of attorney, correct. Thank you, Swati. So that is the capacity actually. The person who signed the contract should have the capacity to sign the contract. There are three things you have to consider. First things, he shouldn't be minor. Firstly, he should have power of attorney, or he should be able to sign the contract. Even if he has the power of attorney, if he's a minor, he can't sign the contract. That means he don't have legal capacity to sign the contract. He should be a major, like 18 years and old. Then the person should have a sound mind. He shouldn't be have unsound mind. Then person shouldn't be disqualified by law. So I will explain, don't worry. So first, minor, that you know that he should be 18 years and more. Then that's the first thing, clear thing, straightforward. then the person should have the sound mind. That means he shouldn't be he should be able to read and understand the contract. He shouldn't be under the influence of alcohol or intoxication. He shouldn't be an idiot by birth, or he shouldn't be lunatic. If a person, some persons are maybe they are mentally retarded from birth itself. They have nervous issues or mental issues. Those persons are legally called as idiots. Legally, they called idiots. Okay, those persons are not have the capacity to sign the contract. Then there is lunatic. That means some person, they are by birth they are normal persons, but when they grow up or when slowly they show some signs of mental illness, phobias. Sometimes they will be normal and sometimes they will be abnormal also. So you can't tell when they will be in a normal stage, or you can't tell when they sign the contract, are they in a normal stage or no. They also don't have the capacity to sign the contract. And then drunken and intoxicated persons. Like if somebody drunk and come and sign the contract, he don't have the capacity. Or someone who's uh, take some drugs, or they had a weeds or something, they also not qualified to sign the contract, or they don't have capacity to enter into the contract. Then there is something called person disqualified by the law. Foreign people. Foreign people are two types: enemies and friends. They call alien enemy or alien friends. Alien enemies can't sign the contract. So say there's a war between Ukraine and Russia. So Ukraine people can't sign the contract in Russia because they have a war declared. War is going on. They called as alien enemies. Then there are convicted person who is in jail, convicted by the law. They also cannot enter into contract. Then people who's insolvent or bankrupted also can't sign the contract. Okay, so when you check the contract, you make sure who signed the contract fulfill these requirements. If these, one more thing I will tell you, some country to country these requirements change. Okay, but minimum these three requirements you have to ensure before they sign the contract. So when you receive the power of attorney, check he's a major, he's not you can put a declaration for that. Please, I hereby confirm that this person is not lunatic, idiotic, drunken person. That's the reason you always have a witness to sign. When you sign the contract, there's a witness also, and witness is responsible for this capacity, by the way, legally. Okay, then we have a drunken person who will never sign the contracts. And if you have you have to check the in power of attorney, you have to check the country or a nationality of the person. When you have a, if there is a contract in Russia, if power of attorney is there, he's major, but still he's from Ukraine, he cannot sign the contract. Okay, these are the about capacity of party. Okay, something called certainty of terms. That means the contract should be crisp and clear and specific. You cannot say ambiguous things in that. Okay, when I say a luxury or premium car, I said premium car. Okay, what is coming to mind when I say premium car? Shahid, what is coming to your mind when I say premium car? Hi Shahid, with us?
Yeah.
What
Premium
is the
is
car?
is
Tell me the car name only.
with the
Tell me the car name.
looks like Lexus.
Lexus. Okay, thank you. Sariga, what is coming to mind when I say premium car?
Tesla.
Tesla. Okay. Safar, what about you? What is coming to your mind?
There will be ambiguous, like many cars will
No.
come to my
Which
mind.
car is coming to? Which car is coming to? First.
Mercedes.
Mercedes. Okay. Rafi, what about you? Is Rafi or Ramsil?
It's a Ferrari.
Ferrari. Okay. See, this is called ambiguous terms. It's not clear actually. five of you have different interpretation actually. That contract you cannot perform actually. There's no certainty of terms. So if you connect to the construction industry, you have mentioned IT work should be ultra luxury. What is ultra luxury means? It could be anything. Now, when I say premium cars, three of us, I mean, five of you have different cars came to your mind. Similarly, when you prepare specification, you have to ensure it's non-ambiguous. When a specification, a contract, you have to mention, this is what I mean. When you put any element of uncertainty, that's ambiguous things. So please make sure the contract does not have any ambiguity. Okay. Now there's called lawful object. So the objective of the contract. Okay. So two-person enter into a contract to construct a building. What is the objective of the contract? What is the objective of the contract? Let me ask to somebody. Dincy, what is your objective of the contract? Two people enter into contract to construct a building.
In that one, construct a building.
Construct a building. Okay.
Yeah.
Okay. Is that lawful? To construct a building is lawful?
Yes.
Yes. Okay. Thank you. So what if two people enter into a contract to kill someone? Is that lawful?
No.
If two person enter into a contract to construct a factory which will fabricate weapons illegally, is that a lawful object?
No, that also not a lawful.
Okay, two-person enter into contract to construct a factory, okay, for refining the wheat or marijuana. Is that a lawful object in GCC? Yeah, specifically GCC.
Yes.
There are countries which is legal also. Is that lawful?
No, that also not lawful.
Lawful. So if the object should be lawful, firstly, you cannot enter into a contract for something to criminal act or an activity which is illegal in the country. Kill someone, kidnap someone, a nuclear weapon, a weapon factory, something like that. You cannot prepare a contract for that. So objective of the contract should be important. Now, the possibility of performance. The contract should be capable of performing. If it's not possible to perform, the law will see it as an invalid contract actually. Okay. Just imagine I'm a magician. Okay. I'm a magician and I'm entering into a contract with someone, say Nizar. Why I'm taking Nizar name? He's my friend, so I can use his name whenever I want. So I'm taking Nizar, and Nizar, I'm telling Nizar, I know a lot of magic, Nizar. I can help you to find some treasure back in India. But you have to pay me, say, 1 million dirham. Are you okay? Nizar say, okay, I can pay you 1 million. He's very happy. He agreed everything.
Hello?
Okay. Yeah. Yes. Hello? Who's this?
Sorry.
Hello, Midun.
This is
Yes,
Nizar.
what happened? Yeah, Nizar.
No, you offered me something.
No, treasure. I'm offering Nizar that Nizar, I know some magics. I learned some new magics. Okay. So I can help you to find some treasure back in India. If you give me 1 million dirhams. Okay. Example. Okay. And Nizar said, yes, I can give you 1 million dirham for sure, but you have to find me this treasure. There's no chance I can find treasure for him. So he will go to the court. Okay. And court will read it. He will say this offer is there, acceptance is there, consideration is there, free consent is there, capacity is there, lawful object is there, certainty of terms are there, but it's not possible to perform. What is the chance I can find a treasure for him? So there's no possibility of performance. If I connect to the construction industry, okay, there's a small contractor, say C-grade contractor, you approaching him and telling him to construct a premium building, something like a premium building, a high-rise building. He don't have any experience. He's a C-grade contractor. You don't have expertise, and you approaching him, maybe for a low cost requirement, you approaching him and telling, dear contractor, come, let's do it. He will be very happy. Firstly, he will be very happy because a poor contractor, when he's getting a big work from a very big client, he would say yes only. 100% sure he will fail. When he fail and when he go to the court, what court see it? See, this is a secret contractor. There's no possibility to perform this work for him. And he would say this is not valid at all. This is called possibility of performance. Similarly, if you approach an MEP contractor to construct a Burj Khalifa, what is the possibility of performance? No way, he's an MEP contractor. How he can construct a Burj Khalifa? There's no expertise for him. That's also something called possibility of performance. You have to ensure the contractor is capable of performing the work or the scope is possible to perform. Okay, then the last one, sorry, no, second last one, not declared as void. That means the agreement should be such that it should be capable of being enforced by the law. Whatever, if all the above are fulfilled, it's not void at all. So this clause you can say you are to, it's a final check before going to sign the contract. Is a final check. You make sure that it's enforced by the law. There is an offer. As everything is valid and legal. That's what called not declared as void. Okay. Then there is the final step, necessary legal formalities. That is differ from country to country. If your country if the contract should be enforced, if your country required to be, it's in a stamped document, translated to Arabic or attached by the authority, then you are to fulfill that requirement. But if a contract in a paper signed by both party, stamped by both party, if it's okay in the country, that's also a valid form contract. Okay, so make sure in your country, whatever the legal formality required, that should be fulfilled. Sometimes your country may need to be attested by the Ministry of Interiors, Ministry of Human Resource, whatever that require. Sometimes Ministry of Municipality authority need to be verified it, better is signed, stamped it. Whatever the requirement in your country, that should be fulfilled also. Only when all these elements are fulfilled, then only you can say, yes, this contract is valid. Only when you ensure this contract is valid, now you can open the contract and you can start reviewing the terms of condition. You can review obligation, you can review responsibility, you can review payment terms, you can review POQ, whatever you have. But first and foremost thing is that you have to ensure the contract in your hand which receive for review is a valid contract. So I'm sure you all will achieve MRICS, and next stage will be like you will be landing as a say senior manager or a director position. And that position, when you reach that position or a manager or a director level, you should first step, or before you give it to your junior, you have to ensure this is a valid contract. There is a valid offer, there is a valid acceptance, there's a lawful consideration, there's a free consent, there's a capacity, everything you have to ensure. Maybe I would say what I used to do, this free consent or a lawful object, lawful things, I used to check with the legal also. I would ask them, legal team, please tell me how I can ensure the legality of these terms. What do you want to do? How I could ensure this validity of offer acceptance, how I can tell this free consent, because free consent is like difficult to explain. How I can explain? He would say like, he would say this, include this document or include a consent document to them, and capacity of terms. You can say when before sign the contract, they have the full capacity to sign the contract, and you also can review them. Then the possibility of performance, that's what LOT you mentioned. The pre-qualification, firstly, there's a pre-qualification you say. You do pre-qualification to ensure they are possible to perform as a work. It's not for the competency. There is a legal contractual element hidden behind that when you do the possibility, the pre-qualification. Okay. So these are the 9 major things you have to ensure before you open a contract.
Sorry.
Yeah, who is this?
Sorry, Mithun.
Who is this?
Yeah, this is Nisar actually.
Yes, Nisar.
Insurance, does it part Does it be part of this document anywhere, or it's
No,
a separate one?
no, insurance is not a document which
Proof? No,
will
I
give.
mean proof of insurance. Sir. Proof of
No,
insurance.
that's again, we haven't opened the contract, as sir. If you want to see insurance, if you want to see guarantee, you need to open the contract. We haven't opened the contract.
Okay.
Still, it's in our table. Okay. We
But
do
you are
the
saying to check
yeah
the elements of a contract, right?
yeah. Where is insurance? I mentioned is contract elements.
Yeah, that's what I asked. Actually, sometimes we ask for proof of insurance.
When we ask proof of insurance in post contract stage, or when you submit the RFP.
RFP, I'm saying.
Yeah, when you submit the RFP, we ask, or in post contract, we say all these things. In post contract, we ask for all the insurance, not proof of. We need all the
Okay.
insurance in place. So that means we talk about the pre contract. Okay.
Okay.
This competency purely pre contract. Whatever happened before signing the contract. Okay. In our RFP document, why we ask insurance? That is because FIDIC says so. So guarantee. Everything. That's all like a subsequent step. Inside the contracts, right? Be it insurance, be it the resource schedule, be it the certification, be it the tender program, everything inside the contract. But we haven't opened the contract as of now. We are just looking into the principal element of the contract and we put a tick mark. When only we will open the contract, Nizar. Clear, Nizar?
No. My question.
Yeah.
We sometimes when we send for tender and we ask them to price something.
Okay.
We will ask proof of insurance.
We ask for PI insurance. We ask for the workman compensation, everything.
Yeah, proof of the insurances. Okay.
Mainly PI insurance, right? You ask.
Mainly PI.
PI insurance, yeah. So
mainly PI.
That's never going to impact your contract. Principles of contract or elements of contract. That's not something impact. It's if there's no proof of insurance, what is the second remedy for that? What are you going to do? What you will do if there's no? You will issue a PTC. Then get it. What we're talking about tender only. Okay. So this is not the PTC. Those all elements, Nisa, be it a PTC, a TQ, a specification, a drawing, all going to be part of the contract. Okay. Before, say,
I got it.
I'll give an example. If there is no consideration, zero consideration, but you include all insurance, everything, the contract is still void only. You cannot perform the contract. If you go to legal, it's a void contract. So whatever you have include inside, it's a useless documents. First, our prime objective is that to ensure the contract is void and valid. Then only, sorry, valid, not void. Okay, it should be valid contract. Then only there is a point in reviewing any documents. In the first instance, is the contract is prepared for a lawful or a illegal activity. Everything is there, still it's not a valid contract. Clear?
Yeah, clear.
Okay. Hi, Maisa. Any doubt from your side? Any confusion or any clarification required from my side on that?
No, I understood.
Understood, right? Ria?
Yeah, everything understood.
Okay. Fatima, how are you? Clear?
Yes,
so
sir.
I hope
Clear. Sorry. Yes,
clear.
Mithun,
Okay.
clear.
Oh, clear. Okay, thank you. So I think now we are clear with the elements of contract. Before I go into next session, any doubt, guys? I'm going to the types of contract. Clear, right? Can I move forward to types of contract, guys? Can I have thumbs up?
Yes, you can, yes.
Okay, thank you. So contract is classified into mainly 4 types. Okay. It's classified to, I mean, you might wonder like, what is this kind of classification? So it's good to know like this classification. Eventually you will be, or I want you to land in a top position after the MRICS. I want you to, maybe now you already in a top position. I want you to move next step of your career when you get this MRIs. Yes. So, so I want you to make sure you know all the basics of contract. I don't want somebody question you and you go doubt about the answers. Everything should be in your brain now. Okay. So it's classified into mainly four types. So one is on the base of creation, on the base of validity, on the base of liability, and the base of execution. So on the base of creation, it's classified into express contract, implied contract, tacit contract, quasi contract, and e-contract. On the base of validity, it classified valid contract, voidable contract, unenforceable contract, illegal contract. On base of liability, it's classified into bilateral contract, unilateral contract. And on the base of execution, it's classified into executed contract, executory contract, partially executed and partially executory contract. Don't worry, when we explain, you will understand exactly what it is. Let's look into types of contract. So it's based on creation. Okay, the first is based on creation. First is express contract, means a contract made by word, spoken or written. Don't look into section, I put a section from Indian Act only. Okay, express contract means that is expressly stated or communicated. Just our old concession contract, which has a specification, it has a form of agreement, it has a fitting form agreement, it has a political condition, everything is there, expressed everything. That means you can physically see the document, physically touch the documents. That is called express contract. Okay, something called implied contract. That means a contract inferred by a conduct of person or circumstances. What does it mean? Express contract, I'm sure you understood. It's everything is there expressly stated. You write the terms of the contract, you write the definition, you write the responsibility, you write the payment term, you prepare the BOQ, everything's expressly stated, and you can physically see those items. Those are called express contract. What is this implied contract and what does it mean by conduct of person or circumstances? This means there is no express, nothing is written. Okay, let me remind you an example which I mentioned. I'm constructing and there is a shop in front of me who is selling cement and rebar. Okay, so what I do, I will just wave at him and show one finger, two finger, like that. When I show one finger, he will send me one sack of cement. If I do two fingers at him, he will send me two sack of cement. So there is a contact between me and me. That means I'm waving at him and my actions or the circumstances show that I want something and he supplied and I pay. This is called implied contract. There is no as called written words. Nothing has been spoken, that's been written. But again, my conduct, my actions and circumstances show a requirement. There's a communication. So I wave at him, I show him one finger, he send me one sack of cement. Now I am obligated to pay. Again, very difficult to prove this kind of contract. It go to legal complications and all. Now something called
brother,
yep.
Is it valid?
Can I explain and come back to this, please? Can I finish it and come back to you, please?
No worries.
Yeah, thank you. Now there is something called tacit contract. A contract is said to be tacit when it has to be inferred from the conduct of the parties, but same time by the silence. I will give you example, then we'll understand. Okay, a conductor submit it's like there is a contractor. He submit a cost proposal. He start the work. You didn't approve it. Okay, you are a consultant or you are a client. Okay, a contractor submit the cost proposal for a variation. You didn't approve it, but he started working, and you never stop him also. So what your action means? Your action means if you stop him, your action means don't do it. But now you just watching him doing the work. That means there is a silence. There is a silent approve from your side. You cannot wait him to fail or wait him to complete the work. This means there is no silence. There's silence that indicate an approval. That is called tacit contract. And there is something called quasi contract. Okay. Again, it's three items are a bit confusing, but just we need to be aware of it. Quasi contract is mainly for to prevent unjust enrichment. Okay, so I'll go to implied contract example. Okay, in implied contract, there's a cost proposal he submitted. Just imagine he's supposed to do some landscaping work in front of your building. Okay, he submit the contract, you haven't approved it. Okay, but he start the work, you going, you visiting, you seeing it, maybe he's giving some opinion also, you coming back. But at the end you're telling, ah, there is no contract, I am not going to pay you. This is a implied contract in place. Now you know that because I didn't stop him and my circumstances, like I give opinions and all, there is a chances. Even if I'm not going, he submit the cost proposal, he start the work, I'm not stopping at all. By after some say a few months, he complete the work and I have a very beautiful landscape in front of my home. But there is no contract. And I'm telling I'm not going to pay the money. There's no contract. Excuse me. The poor contractor go to the court and say there's no contract, I agreed, but I did the work for him and he getting benefit out of it. In this stage, the court will say, dear client, now there is a work he did for you. You get benefit out of it. Same time, you haven't stopped him also. That means you getting benefit out of it. When you get a benefit out of it and you require that benefit, it's called there is a quasi contract in place even though nothing is expressly stated. For example, in your construction project, there is a variation and he submitted and you didn't approve, he start the work and if you at the end you're telling, I haven't approved the work, I'm not going to pay you. If you go to the court, you will be in trouble. So court will not let you to get benefit out of it because you get unjust enrichment. It's not justice. There's no justice for the pre contractor. You're getting unjust enrichment. The court will see you, dear client, you get a benefit, you get a, so now your turn to give justice to the contractor, pay him the money. Similarly, if you say, so a supplier is there is a contract in place or as a PO issued to the supplier, but after the PO value been used, again supplier is issuing and you receiving it also, you using it also. At the end you are telling, no, there's no PO, why I don't pay you. That means implied contract in place, even though you receive the material and you using it also. That means implied contract. So be very careful if your silence or your inaction will not escape you from, help you to escape you from the obligations, or it will not release you from your obligation. There is something called e-contract. That's like there is no paper. It's purely on the softwares. Like sometimes there's NDAs and those things will be sending in the e-platforms. Like we have many e-platforms. Those contractors are called e-contracts. Yes, I'm going back. Who the person who asked the questions? I'm coming back to you, please. Yes, somebody asked me the question. Who's that? Hi guys. I don't know who asked the question. I stopped you in the middle. I told I'll come back. Who is the person who asked the question, please? Nobody? So express types on the base of creation. There is mainly 4 type of contract: express contract, Impaired contract, tacit contract, and quasi contract. Why you need to be aware of this type of contract? Because there is chances you will come across this kind of agreement or contract, say in a variation or a supplementary agreement, which will looks like there is no express contract, but your circumstances, your silence, your benefit may states that, or if you go to the court will seize that in benefit of the other party in these circumstances. Okay, can I move forward to second, or you want me to explain, or you have any doubt? Any doubt? Can I have a thumbs up or thumbs down, please? Okay, I'm going to next type based on validity. So based on validity, it's mainly 5 type: valid contract, void contract, voidable contract, unenforceable contract, and illegal contract. So valid contract means now we know when all the elements of contract are there, it's a valid contract. Say if it has a valid offer, acceptance, consideration, performance of possibility of performance, free consent, capacity of party, then what else, legal formalities, no declares void. If everything is fulfilled, it's called a valid contract, simple as it is. When all the terms of the contract, all the elements of the contract is there in the contract, that is called valid contract. Void contract: when a contract is not enforceable by the law, or when essential elements are missing in the contract, that contract become void. And void contract you will not be able to perform at all. If a contract is prepared, if there is no valid acceptance, that contract will become void contract, and that contract will not be able to perform. Similarly, a contract is prepared for illegal activities. That contract become void because you cannot enforce by the law, and you cannot perform the contract at all. Any contract which you cannot perform at all, there is no chance you can perform, that is called a void contract. That means maybe you agreed for a illegal activity. There may be no lawful objective. There is no possibility of performance, no consideration, no valid offer, no valid acceptance. In this case, the contract is called void contract. You cannot perform the contract legally. Then something called voidable contract. Voidable contract means is enforceable by the law. Subject to condition, it can be performed. Definitions here: an agreement which is enforced by the law at the option of one or more parties, but not at the option of the other, or other is voidable. It's really confusing definition. I will explain in a simple way. A contract is voidable means it can or cannot be performed. Depends on what parties decide. For example, a minor signed the contract. So now it's not a valid contract. It's not a void contract. Okay, it's not void contract. There is legal element, legal objective. There's an offer, acceptance. Everything is there. But a minor signed the contract. Now it's not possible to perform. But when this minor become 18 years old, say he become major, then he can decide whether to perform or not. But again, if an enemy, okay, now Ukraine and Russia has war. The war is completed, or they have it's been resolved everything, and now they become friends again. They declared us we are going to be alien friends hereafter. But he signed the contract when there is a war. Now he can decide whether he can move forward or not. That means based on parties' discretion, it can be performed or not. That means voidable contract. Void contract you cannot perform at all. But voidable contract you can perform, depends on parties' agreement. Okay. Something called unenforceable contract. When a contract is a good in substance, but because of some technical difficulty you cannot perform. An agreement which is required to be stamped will be unenforceable if the same is not stamped at all. So it has all the element of contract. It's a valid contract, by the way. It has what do you call it? It has offer, it has acceptance, everything is there. That means in terms of substance, these elements are called substance. In legal term, it's called substance. So good in substance, everything is good. Legally valid, no legal objective, proper offer, proper capacity, everything is there. But there is some technical defect. That means in that country, if it to be valid, there should be a stamp. If the stamping is not done, that means it's called unenforceable contract. Technical defects only, but again, parties can decide that. Okay, there's something called even a contract which is not stamped. If go to the court will say whether you want to stamp it or not. You want to make it void or not. Sorry, you want to make it valid or you want to make it enforceable by unenforceable. Then something called illegal contract. So illegal contract is something which you agree for a illegal activity. Like you are making a contract for killing someone, kidnapping something, or preparing drugs, or any illegal activities which is forwarded by the law. In your country, that activity is illegal. Then that is called an illegal contract. Country to country, activities become legal and illegal. So some countries, the drugs are say drugs. Some drugs are legal. So that country, it's not illegal, this contract. But in some country, this legal act, preparing drugs is an illegal activity. So that country, it become an illegal contract. Hope it's clear. Based on validity, is classified into 5 types. Based on excretion, it classified into 5 types: express, implied, tacit, and quasi contract. This is very important that these 5 terms. Types on creation, it's very important because you will come across this issue in the post contract also. Whereas on validity, it is something you can understand in the very beginning. So when you check the elements of the contract, you can say it's valid, void, voidable, illegal, or whatever. You can decide that stage and you can take a decision also. Now we have something called based on execution. Many terms are purely theoretical, okay? Theoretical, but again, you can use these terms when you write a letter, draft a letter, when you prepare a supplementary agreement, when you draft a settlement agreement, you can use these terms. Okay, so that's called based on execution. Is classified into 3 types. One is executed contract, other is executory contract, and third one is partially executed and partially executory. The first one, executed contract, that means both parties fulfill their obligation. The contractor construct the building and client paid. That means that was the ultimate obligation. So the obligation of the contractor was constructing the building. He constructed it as per the specification, and the client paid the money also. Now both parties fulfill their obligation. That is called executed contract. Executory contract, a contract in which both the parties have still to fulfill the obligation. That means the contractor enter into contract to construct a boundary wall or a swimming pool. So he is in the middle of the work, and same time the client yet to pay some money. Okay, so that means both parties yet to fulfill their obligations, called executory contract. Now something called partially executed and partially executory. That means a contract in which one of the party fulfill his obligation, other party yet to fulfill his obligation. The contractor, he constructed the building. He completed the full construction of the building, but client yet to pay. That is called executed, partially executed and partially executory contract. So this is the classification based on execution. These terms, they might not be asking for MRICS, but I want you to learn this for your day-to-day career. And trust me, when you draft a contract or draft letter, you might be using these terms for sure. I think it's straightforward, these three terms. Any doubt, guys, on these three terms? Before I move forward to next last session, any doubt? Can I have thumbs up, please? Thank you. Then there's a last section called types of contract based on liability. It's two types actually, bilateral contract and unilateral contract. So a contract in which both the parties commit to perform the respective promises called bilateral contract. So as a contractor, I said I'm going to construct the building for you, and he said I'm going to pay for you. But when work started, okay, the contractor is not doing any work. He plainly demonstrated he don't have any intention to work. That's called bilateral contract. It's a legal term. Okay, only when such issues it go to the legal doctrine or legal proceedings, they will use this kind of wordings. A contract in which both the party commit to perform the sorry, I think I explained mistakenly. Sorry, a contract in which both the parties commit to perform the obligations called a bilateral contract. That means he is commit to construct the building and you as a client agree to pay him. That is bilateral. Both the parties agree to perform their respective promises. I'm okay to pay you and you okay to construct. That's called bilateral promises. There is something called unilateral contracts. A contract is one-sided when only one party has to perform his promises or obligation. Okay, so here there's no two-way obligations. Only one party will be obligated to pay or be obligated to fulfill the obligations, or only one party has to fulfill the promise. For example, say A and B people. A want to get his room painted. He offers Rs 500 to B. And if I have spare time the next Sunday, I will paint. That's what the response from the B. If anybody knows about the condition precedence and condition consequence, are you ever about these two terms? Condition precedence or subsequent? Are you aware these two terms, condition subsequent and condition precedence? Nisar, you heard of these terms?
Yeah, like you're saying about if a thing happened, the like a follow up, right? Subsequent.
No, two terms called condition precedent and condition subsequent. You heard of those terms? So that means, to fulfill the obligation, some condition has to fulfill. Then only he will fulfill the obligation. Okay. So in this case, first guy said, you have to come and paint my room, or just a contractor. I'm telling him, you have to construct a landscape for me. He said, I will come and do only if it rains or only if I'm free. That is called condition subsequent or precedence. Subsequent, if that condition happened, I will do the work for you. That kind of contract is called unilateral contract. If in the post contract, if any agreement or any variation, if there is a condition to be fulfilled, that called unilateral contract. If he says, I will do the work if you get approval, if you get NOC, if you get municipality permit, then I will do the work. That is called unilateral contract. But if he says, I'm going to do the work, then when you say, I'm going to pay you, then it's called a bilateral contract. Okay. So that's for today, guys. we covered elements of contract. We covered different types of contract based on execution, validity, liability, and others. What do you think? You have any doubts? Because we what we covered is the principles of contract. I haven't explained you the terms of contract. I haven't explained you the forms of contract. Whatever I explained is something will happen behind the screen of the contract. Before you get the contract, these things to be required. Okay. I know it should be a bit confusing the first instant, but I will appreciate if you could come back to me or put questions. Then we will explain over and over again. And I will really appreciate if you could just go through session one more time. Then you will get more clarity about what I explained. Okay. If you have any doubts, please ask us. Sorry, ask me. If not, it's 10 o'clock now. You can drop off. And you can once yeah, who's this?
It's Rafi, brother.
Yeah, Rafi, please.
Brother, will you share this slide?
I will be sharing the slide by the end of the session. When I finish the full session, I will be sharing everything. If you look at a slide, it's like some 100 pages slides actually. Okay. I will just show you. It's really 100 page slide. Than slides, even because now how many pages we covered? We hardly covered 3 pages. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. That's it. Okay. But we took 2 hours. It's not about slides actually. It's about like what we explain in classes. Okay. But I will be sharing slides for sure. Definitely I will be sharing slides, but I used to do once I finish the session, I'll be sharing the slides. Okay.
Okay.
And just tell me, like, this is the first class for me for this batch. If you have any feedback, please give me. You want me to slow down my explanation? Or if, I told you I have some stammering issue. I don't know whether I told you I have a 1 degree stammering issue. So my pronunciation might not be clear always. So if you're not able to understand, please let me know. I can explain or I can slow down my the explanation pace or something. Okay. And please, happy to receive feedback because that will definitely help me to improve in upcoming sessions. This is the first session. If you are not giving any feedback, I will assume like everything is perfect, but I'm sure it's not perfect. There is no everything perfect. So if you could give me feedback, I will add more examples, reduce examples, or I will give more real life examples, or I will try to refine myself and refine the classes. Okay. Over to you, please. If no feedback, you can message me also. If you don't want to speak over here, you can message me also. And if all in good shape, good night. You can drop off, but I'll be staying here for 5 more minutes for in case if you have any doubt. Thank you guys. Thank you very much for the participation also. It's really a good interactive session. Thank you.